And I believe we are live now. If someone can post in the chat that you can see and hear us, that would be great. Technology is sometimes not fun.
And that you can see the slides.
So, okay. Here to start streaming. Well, we already started streaming. We got you. Awesome. Okay, so we're live. Hi, everyone. Happy Friday. It's Friday, right? It's been one of those weeks. We want to thank you for joining us. This will be recorded and shared on the YouTube channel, the ArchCity Defenders YouTube channel later today. We want to thank you for taking the time to join us. We know this is a time of a lot of uncertainty and just not an understanding of what's happening in the courts, what people can do with their cases in the courts. We tried to compile as much information as possible to help you understand what you can do to address your cases during this time. So William Waller's joining me, and he is the managing attorney for direct representation. He is our go-to muni court expert, and I will be watching the chat. So if you have questions, please don't hesitate to add your questions to the chat, and I'll make sure we get them answered during this time. So William, I'm gonna go ahead and throw it over to you.
All right, well, hello everybody. As Jackie said, I am the managing attorney for direct representation. I've been practicing criminal law for 8.5 years or so, and a lot of that time I've also been in the municipal courts, which is a very similar sort of thing. And generally, ArchCity, most of our attorneys are in municipal court frequently. We share information, so that's where all the stuff in this presentation is coming from. We will go to the introduction where, well, actually, first, let me acknowledge some significant contributions made by my paralegal and civil advocate, Shannon Besh, who gathered a lot of the court-specific information and compiled the spreadsheet that I think you'll find very helpful that we'll talk about. And also Simone Palmer, our digital media associate, who made this look nice because I didn't do any of that. So that said, what is the purpose of this presentation? Most people in municipal court don't have attorneys and sort of have to fend for themselves. And it's gotten especially complicated because the Missouri Supreme Court has closed the courts. First it was to mid-April, now it's till May 1st. It may well go longer than that. So everyone's sort of in a holding pattern, and what can you do if you have cases you want to deal with or if you have warrants you want to deal with? We're going to try and give you some ideas, and I'm happy to answer any questions you have, although I must say that this is not legal advice because we haven't been retained as your attorneys, and I can't get too specific based on your circumstances, but you are welcome to apply for our services, and we'll have that information on here as well. There should be links in the description to some of this stuff. If there's a website on the slide, it should be linked in the description. Yeah, so there are dozens of municipal courts in the St. Louis region, mostly St. Louis County. St. Louis County has its own municipal court system, north, west, south, and central division. St. Louis City has its own municipal court that processes a whole lot of cases. And then of course there's St. Charles and further out state. Most of what we talk about will apply to all of them. Sometimes we'll get specific to the extent we can, but really it is all about the specific court you are dealing with, and you got to find out how they do business. There is this Missouri Supreme Court Rule 37 that's linked here, and we'll talk about specific aspects of that rule that are universally applicable, but not all courts really follow that rule or what's in that rule. It's sort of vague, and there's a lot of discretion even within that rule as to how they want to operate. So, but it is a useful resource, so that's why we've linked to it. So the first topic and first thing you may want to figure out, where do I have cases or warrants? You do not want a warrant pending while there is this outbreak happening, because you don't want to end up in jail, which is one of the worst places to be during an outbreak. So if you have warrants, you want to know about them and you want to know what you might be able to do to get rid of them for the time being. So pretty much every court in the region in St. Louis County, with some notable exceptions, is on one of the databases that we'll talk about. The biggest one is Missouri CaseNet, case.net, which is where all state cases are, civil and criminal. So you may be familiar with it for that reason. All of the courts as of July 1st of last year were supposed to be on, in St. Louis County, that is, were supposed to be on CaseNet and accessible there. These municipalities are taking their time putting their cases on. A lot of them have new cases as of a certain date on there, and the old cases you either have to call them or you have to go to one of these other databases to check. And you'll also find on Missouri CaseNet all of the cases from municipal court that were certified for jury trial. Either someone asked for a jury trial in municipal court and it got sent to the Associate Circuit Court, or they had a municipal bench trial and asked for a trial de novo or new trial, and then it got sent to the Associate Circuit Court. But that should be your starting point, is checking CaseNet, especially if it's a more recent ticket or case that you have. Municourt.net is the other big one, and a lot of places that were on there are now moving to CaseNet, but their old cases may well still be on Municourt.net. St. Louis City is still using that database, and you can put in your name, your year of birth, and you should be able to see either select by a specific municipal court, or you can search all of them. But the reason you want to look at that drop-down menu that selects specific courts is so you know which ones show their cases on Municourt and which ones are not on there. So that's worth searching as well. St. Louis County Municipal Court, which is confusing because all these cases are in St. Louis County for the most part. All these courts are. The county on the county level with county ordinances has its own municipal divisions, north, south, west, central, that issue cases for areas that aren't incorporated to like a smaller municipality, or if you get pulled over on an arterial roadway, a major road throughout the county, you might get a ticket that is filed in that court. They have their own case database. It works a lot like Municourt.net, and there's a lot of information you can gather from them. It's linked here. The other big database is Regis. I just mention it because it's out there. It's how we run people for warrants, but most people, unless you work for like a police department or a law firm or something, will not have access to it. So it's worth noting, but you can probably ignore it. Again, there are courts that are in violation of the presiding judge's rule, or the former presiding judge's rule. And you just got to call them to find out if you've got cases or warrants there and hope you reach somebody. Big ones include Jennings, Ferguson, but there's also Calverton Park, Hillsdale, Moline Acres. Then there are also courts that have a database you can access online, usually through their website, but it is just their cases. A big one is Maryland Heights, St. Louis County Municipal Court, as we've talked about, and some others, Manchester, Wildwood. But as opposed to having to check all of these, this spreadsheet, which should be linked in the description, should tell you, both give you contact information for the court, the most recent contact information we could find, and also tell you which database they're using and whether it's for new cases or old cases or both. So hopefully that is a helpful resource. If you think you were pulled over in a certain city, municipality, or you think you have tickets from somewhere, you can use that to help you find out for sure. So if you have a warrant, it's because you have a case, but the warrant is obviously the more pressing issue. So how do you take care of a warrant if you have one? So it depends on the type. I just want to mention this because it can be confusing, but there are arrest warrants, which are when a new charge is filed by the prosecutor, usually after you get a ticket. They will sometimes ask for an arrest warrant from the judge in that municipality. It is rare because they're only allowed to do it under certain conditions under Rule 37.43. The vast majority of cases start out with a summons, which will probably be sent to your last known address. But the flip side of these being rare is you probably won't know if you have one. You could suspect you have one because you were pulled over or you had a police interaction where they said they were going to charge you with something and you're like, what happened with that? It may be that they issued the case and they tried to send you a summons, or that they issued an arrest warrant. So basically, if you think you have a case, a brand new case you've never been to court on before, that's something to check into by contacting the court to find out if you do have an arrest warrant. The vast majority of warrants, though, that you'll be dealing with, you'll probably know about because you had a court date. You didn't go because you were unable to. Maybe you even called them and said, I can't make it to court, and they were like, tough luck. But these are capious or failure to appear warrants that are issued when you don't show up to court on a pending case, like a newer charge, or if you've even pled guilty and you were sentenced to something like a fine, and then you're given a date on a payment docket, or they say pay by this date, or show up to court, then you could still get a failure to appear warrant at that point too. And in that other case where you have already pled guilty and you have a fine that you owe, they'll often set the bond amount attached to the warrant as the amount that you owe. So the idea is you get arrested, you have to post bond, or you want to post bond before you're arrested, then they can just seize that money and pay out and close your case and say, okay, you paid us. They're not supposed to be able to do that automatically, although some courts will. This is they abide by the law to varying degrees depending on the court in question. So under the current circumstances where the courts are actually closed, you don't have a docket, you can't just go into a court and talk to the clerk during normal business hours. Some of the courts are dealing with the situation differently, others haven't made any adjustments. The best case scenario is it's a court that has just quashed all the outstanding warrants they had. They canceled all the warrants they had once this whole thing started. And as far as we could tell, Overland and Oakland are the two that have done that. Others have made it easy to take care of a warrant. They're not going to automatically just quash all of them, but you can reach out to them either by calling or making a written request, depending on the court, and they will cancel your warrant and give you a new court date. So the ones that seem to be doing that automatically are Florissant, all the consolidated courts in Normandy. Normandy is the main one, but there are other courts that are held there under the same judge. Jennings, Breckenridge Hills. There are also some others that have indicated to us, at least, that they're going to, you can contact them in writing to ask to take care of a warrant, and it will the clerk will give it to the judge, who will then decide whether or not to cancel your warrant. All the courts in St. Anne, which has a number of courts held there, like Veneta Park, for instance. Ferguson has indicated that's what they're doing, Bridgeton, St. Charles City. And there may well be others, because we tried to reach out to all the courts and just weren't able to get a hold of everyone in time to make a complete list. But that does seem to be a trend, and hopefully something you can take advantage of. The third option is they keep the warrants that they have out there, but either they tell their police department not to serve the warrant in case, like say you get pulled over, cop runs your name, sees you have a warrant, but there's some indication in Regis that the court is not going to bother picking you up. So the cop might tell you have a warrant, but they're not going to take you in for it. Or they might book you and then release you with a new court date automatically, because it's not under normal circumstances, they could hold you until you post a bond if they wanted to, even after you've seen a judge. So the fourth category is the business as usual. Generally the really bad courts that are handling warrants as they always have in spite of the extraordinary situation we're all in right now. So some of them that we've confirmed are still doing that are Pine Lawn, Bell Ridge, Dellwood, St. John, University City. There are probably others that don't see why they have to change. And so if you have a warrant from them, it will have a bond amount attached, which you can find out hopefully from the clerk. The idea is if you want to get rid of that warrant, you either hire an attorney or you pay that bond. And if you don't do that, then they're going to wait till you get arrested and you'll see a judge while you're confined, who will usually release you at that point. As I said, attorneys can, in 99% of cases, take care of that warrant for you, but these courts sort of have a two-tier system where if you have an attorney, they'll get rid of your warrant, and if you don't have an attorney, then you're going to be paying for it. So obviously, if you're in categories 1 and 2, if those are the courts you're dealing with, you're gonna either it's already taken care of, or you're gonna want to reach out to the court and ask them to set aside your warrant. What do you do if the court is not in those categories? Well, the most obvious option is to post your bond, because a warrant will always have a bond attached that you can post to get out. Sometimes you can find that information on CaseNet or municourt.net, but even if you see it on there, you should call the court to clarify. Some courts do it per charge, like you have $100 on this charge and $100 on this charge, or per ticket. Others just do one bond for all of your cases with them. But some of them don't allow you to post the bond until you've actually been taken into custody, which is not a great situation. And you want to know that ahead of time before you go there to try and post your bond, if you can afford to do so. Some of the ways, again, reach out to the court, find out how they allow you to post your bond. Some of the ways that that happens are listed here. It depends on the court. If you can afford to do so, you can also retain an attorney, and like I said, 99% of the time that they can get the warrant canceled for you without posting a bond. Maplewood is a big exception. There might be others where normally they would cancel your warrant, but only if you appeared in court with your attorney at the next docket. Obviously, you can't do that if there are no dockets, so it's not clear how they're handling the situation now. Call that court, talk to the clerk, and find out what they're doing in this situation, or more likely, if you've retained an attorney, then the attorney should be doing that for you. If you do retain an attorney, make sure you know the extent to which they've agreed to represent you. We treat municipal cases like even a serious criminal case. We'll go to court as many times as is necessary to resolve it. Sometimes, like if you go to the traffic law center and you pay them $100, the understanding is they're just going to enter on your case, and they're going to get a recommendation from the prosecutor, which they'll send to you, and they're going to say, sign this, pay what they say you owe, and we're done. We're not going to help you anymore. There's obviously a spectrum in between that. There are some very good conscientious attorneys, and there are some like the traffic law center where you're not getting very much because you're not paying very much. So you want to know, make sure you're clear with the person, the attorney you're trying to retain, what they're going to do for you, if they're actually going to go to court for you. Now, obviously, our services are free. We have the application link to, or the online application there you can fill out. We can't represent everyone who applies for our services, but we do our best. So we welcome you to apply for our services if you can't afford an attorney. If you can't afford the bond and you can't afford the attorney, which if you can't afford one, you likely can't afford the other. What do you do then for those courts that won't just quash your warrant? Well, again, the first step is to reach out to the clerk and find out what your options are. Theoretically, you should not have a bond that you were unable to post. That's what the law says. In practice, courts pretty much ignore that, but you can put the screws to the clerk and say, look, I cannot afford this bond you set. What are my options to talk to a judge and to get a different bond or get the warrant taken care of? Make sure you know your case numbers ahead of time. So you've looked in the database and found what your actual case numbers are, because that's how courts mostly track cases. And if you have to file something like a letter or a motion to cancel the warrant, you're going to want to be able to put those numbers in there so that if you get the relief you're asking for, it will apply to all of the cases that you have. If you can't get a hold of anybody, if the clerk says, nope, the situation is just like it always is, you got to post your bond or you got to wait till you're arrested. Don't take that at face value. Certainly an attorney would not. Consider mailing something in, a motion, or even just a letter that includes everything a motion would, saying you intend to appear in court on your cases, you'd like to resolve them, you are willing to appear, but you have this warrant. You cannot afford to pay the bond that's been set, and you want to show why that is with a financial affidavit if possible, which we'll talk about later. You are filing a motion, you would like a hearing with the judge on this motion that you are filing. The courts should be doing, to the extent they have to, television or telephone or video hearings. And ideally they say, okay, that's more trouble than it's worth, and they just take care of your warrant. Hopefully that should happen in some circumstances, but at the very least, you are demanding your right to a hearing on your motion, which as a defendant, you have the right to file. If they deny you that, if they say, nope, there's nothing you can do, you can't file this motion, you can't have a hearing, you can reach out to us and let us know that's something we'd be interested in hearing about. They shouldn't be doing that. But I can tell you right now, some clerks will probably give you that response because they don't know what they're doing. What happens if you're actually arrested on a warrant before you can do any of this? Generally, most of the time, I would say, the court will the cops will book you, take you to the station, book you. They'll probably already have a list of dates to give you, and they'll just release you after you're booked. And the warrant will be canceled. You'll have a new court date. The big exception to this, which is true of a lot of people, unfortunately, is if you have warrants in more than one place, the department that arrested you for, like, say, Normandy Police Department takes you into custody on a warrant, books you, they're going to release you with a new court date for Normandy. But you've got Pine Lawn as well, who has a warrant out for you. Normandy will hold you and reach out to Pine Lawn and say, hey, we've got this person in custody. We saw you have a warrant. Do you want to come get them? Pine Lawn may say yes, hold them, we'll be there soon, or they may not respond at all, or they may say no, don't worry about it, let them out. it all sort of depends on the relationship between the courts. So you could be held an additional amount of time, even though Normandy is releasing you because you have warrants in other places. And if you have warrants in a lot of places, this process can take a while. We call that the Muni Shuffle. It's probably better than it used to be, but it's still a real possibility. And one of the messed up parts about it is Pine Lawn says, nope, you know what? We're not able to come get that person right now. Normandy releases you and you still have that warrant from Pine Lawn. That's like, in many ways, the worst case scenario. So something to be aware of. I just put the rule there so you can see what the actual rules say about if you are arrested on a warrant. It says rearrest of defendant because this is after you've been to court on a case, you've had your initial appearance, and say you don't come to court and there's the failure to appear warrant. This would be when this kicks in. They have to let you see a judge within 7 days. Thankfully, most courts have an arrangement where you'd see a judge more frequently than that. And most of the time when you do see a judge after that, they'll let you out. Another thing they might try to do is say, okay, well, you've been locked up with us for a few days. You have these open cases. We want to resolve them. We'll give you time served if you plead guilty right now. It's harder to do that than it used to be because you cannot, under Senate Bill 5 passed a few years ago, you cannot give time served or jail time at all for minor traffic violations, which roughly is anything that is 4 points on your license or less, with some exceptions. So if you have a expired plates ticket, or you have even if no insurance ticket, which is 4 points, they can't give you time served on those. So they can't neatly wrap up all your cases if you have those other stuff, that other stuff. If you've got like a trespassing case or a driving while suspended case, they might offer you time served because they can do that. It's tempting because it closes your cases. You don't have to pay anything, but you need to be aware that if you do that, first of all, it's a conviction. So if it's something you don't want on your record, that might cause problems for employment, like stealing, assault. Don't do that because that will be a conviction. People will see that on your record. If it's traffic stuff and there are points associated with that, you will take those points and that could either suspend your license or revoke it for a year. 12 points revokes your license for a year. At 8 points, you're suspended for 30 days, then 60 days, then 90 days. So that may not be the best option. So if you don't have a warrant or if it's taken care of, you've got a case that's pending, you haven't pled guilty, can you do anything while the courts are closed? Unfortunately, there's not a whole lot you can do. It's very dependent on the specific case and the specific court, but there might be things you can do now that will set you up to resolve your case later and put you in a better situation. One of the reasons you don't want to just, if you get a traffic ticket, a lot of times you can just pay it without ever going to court based on a fine schedule. You don't want to do that necessarily because if there are points attached, you need to go to court to get the prosecutor to amend the charges to something like illegal parking so that you don't take points and don't get your license suspended. Points can also make your insurance rates go up. You probably want to avoid that so you can continue to drive legally or get to a place where you can drive legally. You probably also want to know if you've got a good defense, if you can beat the charge, because that, believe it or not, there are a lot of cases you can beat if you really are willing to fight in municipal court. They don't do the greatest job investigating. They don't do the greatest job as prosecutors, getting their case together all the time. It depends. So you probably want to at least explore that possibility and talk to an attorney about it if you can. One thing you can do if you had an April court date and you were planning to go, it's not happening. Call the court, call as many times as it takes, find out when they're actually resetting your case to. And if the order gets extended, the Supreme Court order gets extended past May 1st, call again, find out. Just keep tabs on it, look on the database, make sure you know so that you're not missing court. If you did miss court under the circumstances, I would hope that they would be lenient, and most places probably would be, but still, you want to be aware of your new court date. We talked about traffic tickets. One of the links here is from the Department of Revenue and will tell you which charges carry which point amount. So hopefully that's useful in determining whether or not a traffic ticket will put points on your license. Another thing you can do in the meantime, while the courts are closed, is you can get your license legal so that when you do go to court, you can show that to the judge or the prosecutor, and you can possibly get your charges amended. The number here is the Department of Revenue. That you'll probably be on hold for a while, but they will tell you exactly what you need to do, including specific ticket numbers that you need releases for in order to get your license reinstated. If you're eligible, you might not be if it was revoked, for instance. You might have to wait until that 1 year is done, and then you're eligible to reinstate it. A very common thing that courts do if you don't show up is they'll put a hold on your license, which they can only do for traffic-related charges. But that's what most people are dealing with. This is either called a lieu of bail hold or a FACT, which roughly is something like failure to appear in court on a traffic ticket. I don't know the exact acronym, but they're both under Missouri state law. And essentially, you need either a compliance or release order that the court usually sends to the Department of Revenue, and that allows you to get your license reinstated once they process it. And then once they process that, you probably have to pay a $20 reinstatement fee, which you can do online at that mydmv.mo.gov link. If you have questions about this process, again, you can call the number. There's a frequently asked questions section we've linked here. It is very much dependent on your specific situation. But one of the obstacles you might run into that I want to touch on is, if you need that release order, it's sort of up to the court whether they're going to give it to you. So you won't need to reach out to them and you need to say, hey, what do I need to do to get a release order? Because the worst case scenario is they say, we're not going to give you one until you've pled guilty and paid what you owe. Or if you've already pled guilty, pay what you owe. And at least if you haven't pled guilty yet, the argument I would make, and I do make to prosecutors and judges, is you have to release this person's license because we can't resolve the case until they get their license reinstated. And sort of you're in a catch-22 if they're like, well, we want you to pay us first. No, we can't resolve the case until you release the hold and we can get their license reinstated. It's a complicated topic, but call the number and find out how you can get your license valid and go from there. Jackie, how are we doing for time? I don't have time.
We have about 13 minutes left.
Oh, shoot. Okay. I've been long-winded, and I definitely want to give time for questions.
23 minutes, but 13 minutes for if you want time for questions.
Oh, okay. 13 minutes for the presentation. Good.
Yeah.
All right. So another thing you might be able to do in the meantime is write a mitigation letter to the prosecuting attorney. Again, these are things that I, as an attorney, will do on my client's behalf because they get results. Not all the time, but a lot of the time. They're probably not going to find their prosecuting attorney. You might not even find their name online, much less their contact information. So you need to get that from the court and insist that they tell you. At the very least, you should be able to send a letter to the court, attention prosecuting attorney, and they should be able to receive it that way. You can ask for things like dismissal of your case, decreased fines, amending the charges so you don't take points, or even a suspended imposition of sentence probation, which is another way of avoiding points on your license, or avoiding a conviction for a non-traffic offense if you're willing to be on probation. See what they'll give you, see what they're willing to do. The purpose of this is to get a bunch of information in front of the prosecutor, sort of overwhelm them, show that you are on top of your case, and that you are what you want, show them what you want, and hopefully it'll put you in a better position than you would be normally in negotiating with a prosecutor. So for traffic cases, provide as much proof as you can that your license is reinstated, that your insurance is current, that your car is now registered if you got an expired registration ticket. You always want to include financial information as to why you can't pay. And we'll talk about the affidavits again that you can use to do that, that you can attach to this letter. But you want to paint a picture, like, even if you have some income, if you're the sole provider for your family, if you've got several kids, if you work long hours and can't do community service, which is oftentimes going to be the prosecutor's response if you can't pay, if you've got mental health problems or disabilities or health problems that come into play, lay that all out, paint a picture for them, and oftentimes you will get a much better result than you would be otherwise. And one thing to note is, like, even if community service is the default instead of fines, if that's likely to be the response, no one can do community service right now. We're all under a shelter in place order. You can't, unless you live at a nonprofit or a church, you cannot do community service. So that's something to point out, I think. But one caveat, do not discuss the facts of your case. Do not say, I didn't do this, I'm innocent because XYZ. That will be used against you. Remember your Miranda rights. When the cops arrest you, they say, do not, anything you say can and will be used against you. That same goes for stuff you write down in a letter to the prosecutor. The prosecutor is the one prosecuting you. Do not give them ammunition. That's for trial, when you want to tell your side of the story, or for your attorney to say, because if your attorney says it, the prosecutor can't attribute that to you. Your attorney said it, not you. Okay. I believe this is the final topic, but let's say you have a case that you've gone to court, you've pled guilty, or you signed something pleading guilty through your attorney. You owe fines, which is the vast majority of cases. They want money. That's their motivation. And you probably owe court costs as well. How can you deal with that situation right now without going to court? So I'm going to take a drink here. So these are referred to by the courts as assessed cases, meaning a fine was assessed. They're not closed because they're not fully resolved, but sort of we're past the initial stage of, are you going to have a trial or not? And they can still be in warrant status if you didn't make your payment that they told you to make, or you didn't appear on the payment docket that they put your case on, even if you were unable to pay. So Rule 37.65 is the key rule here, and we'll talk about it in more depth, but basically you're going to want to look at this language and use it to help you. It's relatively new. I think it's from 2 years ago, maybe, that they changed the rules and added this. But when a fine, fee, or cost is assessed, or thereafter, any time a fine, fee, or cost is due, which is essentially any time after it was assessed, if you tell the court you're unable to pay the amount that's due, the judge shall inquire as to your ability to pay. This is powerful. They can't, you have the right after a fine is assessed to say, I cannot pay, and you have to actually look closely at why that is and consider other options as a judge. Section B is if you can pay part of it, essentially, like it says the judge can put you on a payment plan. That usually happens at the time you plead guilty and the judge asks, like, and you say, I can't pay it all right now. So the judge says, okay, $50 a month or something like that. But if, like most people, you live paycheck to paycheck and you want a shot at getting rid of the whole amount, Section C is what you want to look to. So it lists what the judge should consider, the violation, what type of violation it was, your financial circumstances, disabilities, driving restrictions, transportation limitations. Those matter because you might not be able to obtain employment because of them, or you might not be able to do community service if you can't get to where you need to be. Caregiving and employment responsibilities. If you have to take care of your kids and can't work more to make more money because of that, or can't go do community service because of that, that's something the judge must consider. And the judge can do any of these things up to and including just getting rid of the fine or fees you owe entirely. And if you don't have excess money, that's probably what you're going for. Like I said, the default with judges, as with prosecutors, is community service instead of fines, but no one can do community service right now. So now is a great time to make this argument. And what an attorney would do is we'd file a formal indigency motion with an affidavit attached that lays out your income versus your expenses, shows you don't have money left over, and asks the court either for community service or, better yet, to get rid of the fines owed entirely. And the judge might rule on it. The judge might set it for a hearing where you come in and they ask you questions under oath. You can do almost that exact same thing. It's going to be a less formal process maybe for you, but you have every right to do it, just like an attorney would on your behalf. So file a motion, ask for abatement of fines if that's what's appropriate, which it may well be. Ask for a hearing as necessary. This can be a letter. It doesn't have to be like a formal motion. The judge will know what you're trying to do. You're going to want to find out from the clerk how you can send this in if you don't have access to a printer. And there should be some sort of email address that allows you to send this in. You're going to have to attach a separate affidavit laying out your income and your expenses. And that's a sworn affidavit. So it's under oath. You want to cite to the text of that rule and say, here's what the rule requires you to do, and here's what you could do for me, and here's what I'm asking you to do. Cite to that text. And explain fully your circumstances and why you're unable to pay. That a payment agreement would be overly burdensome. Why you can't do community service right now, because again, no one really can. So that affidavit you're going to attach to sort of be the proof. A lot of courts have their own. Call them, find out if they use their own. If they don't, the Missouri Supreme Court has one linked here, which is pretty thorough, but there's no way to submit that electronically. You'd have to print it out and mail it. So if you can only do it electronically, you can also use this informal pauperous motion, which normally in a civil case you'd use to say, I can't pay the filing fee, so you have to waive it. And that is a fillable PDF that you can then save and send in an email. So use that if necessary. And a few guidelines about that to keep in account. When I say make sure that your income and expenses cancel out, like you don't have any money left over at the end of the month, that's because if you do have $10 left over, a really terrible judge might say, well, that's $10 you can give us every month. You're going to give us $10 a month for the next 5 years. You want to avoid that if possible. You don't want to lie, because again, this is under oath, this is under penalty of perjury, but most people live paycheck to paycheck. They don't have excess money left over when you really think about it. If there is excess money, you're probably not accounting for something for one of your expenses. You'll have to include personal property you own. I guess the idea is you need to sell your car, your only means of transportation, to pay your court fines. That's unreasonable. That shouldn't be the case, but that's why you theoretically include that in this affidavit. That actually can work the other way though, because most people don't actually own their car. Most people don't actually own their home. They have a loan, they have a mortgage, and you own some of it, but the rest of it's debt that you have to pay on every month. So make sure you include that debt you're paying every month and make it clear, I don't own a $200,000 house. I own $10,000 worth of the house and I owe $190,000. Student loans too is one you should absolutely include. So hopefully that all made sense. That gives you something you might be able to start on. Here's our contact information, and again, how you can apply for our services online if you need them. Want to make some time for questions if there is any left, Jackie?
Thank you, William. I right now am looking at the chat in the live stream and want to give a second for the time lapse to catch up to see if anyone has any questions. I do have something, William, that might be helpful to touch on. One of the frequent questions we receive right now is that the courts are closed in Missouri through May 1st. However, we know that the stay-at-home orders are being extended into mid-May at least. What should people do if they believe they have a court date on May 2nd, May 3rd, May 4th? How should they handle that? What is the best information that you can give them?
So yeah, the stay-at-home orders are from cities like mayors and from governors, whereas the court closure is from the state Supreme Court. So those might conflict potentially. If the state Supreme Court doesn't extend their order, you might be under a stay-at-home order from the mayor, but the court is theoretically open. That's a tricky situation because the court would probably be considered essential business. And a really terrible court would say, we don't care if you're endangering your health, but you have to appear. I would certainly reach out to the court and say, normally I'm totally willing to come to court, but in my city, the mayor has issued a stay-at-home order. I do not feel safe. I do not feel like exposing myself. I would like a new court date, and see if you can get one. I think any reasonable court would not be setting dockets if there are still stay-at-home orders, but that's actually a situation where you should reach out to us too, because we'd be interested in knowing what courts are basically risking people's lives so that they can resume making money.
So what should people do? Where should they go to get that information?
As to if the courts are resuming?
Yeah.
You gotta connect with that individual court. Go to their website, see if they have something. In my experience, the courts are very slow at catching up to the orders that are happening. I still have clients who have court dates set late April. I do not think there actually will be court on that date, and I'm not worried about not showing up and the court saying you didn't show up and your client didn't show up, so there's a warrant. But I think you got to get in touch with them, and you got to follow. Even if you can't get in touch with them now, you got to follow up as soon as possible after courts do resume to say, here was the situation. And that's really the best you can do.
Thank you for that. Also, as kind of a shameless plug, following ArchCity Defenders on social media, we have this YouTube channel. Obviously, we also have Facebook and Instagram and Twitter accounts, and we try to update that information. We also have the stlcovidhub.org, stlcovidhub.org. And you can go to those links through our social media and our website as well. That's our advocacy site that outlines the calls to action that we made for government and other officials to think about how the COVID-19 pandemic is impacting the most vulnerable in our community and how we can support them through this time. And so the calls to action live on that website, and we update that as frequently as we can so that you know the status of those. And one of those calls to action is court closure, and there are links to some of the orders that the courts have issued. So stlcovidhub.org, ArchCity Defenders on Facebook, Twitter, Instagram, YouTube are all the resources where you can get that information. I also want to add, I think it's really important that people know that they do have rights, and a lot of these courts, as you know, William did a really good job of explaining how the courts work, and some of the courts are not fully in compliance with the rules. And to the extent that you're running into these encounters and these issues, please let us know, because we want to advocate for you. And we can't, as much as we try, we can't be everywhere we want to be and need to be. So you need to make sure that you're sharing this information with us. You can email us at mail@archcitydefenders.org or intake@archcitydefenders.org to share information about what's happening in the community. I do encourage you, the best way to apply for services is through our website at that link, and we will get back to you as soon as we can. We have a little bit longer of a lag on application review during this time. So please be patient with us. I also want to add that the slides that William has reviewed during this webinar will be on our website, along with the slides from the one that we did on the landlord tenant stuff. So I'll try to get those up by the end of the day, if not by the end of the weekend. And we'll also make sure that we have the links to those on our social media so you can access these slides. I don't see any additional questions. William, do you have anything you want to add before we leave?
I did want to add, under normal circumstances, we'd welcome people to just come to our office to potentially fill an application with one of our paralegals / civil advocates. Obviously, our office, like most places, is closed, and we don't know when it will reopen. So again, that's one of the reasons the website is the best way to apply for services.
Yeah, thank you for pointing that out. You can go to our website and get a paper copy of the application to fill out and mail. That will just delay our review of your application because of mail forwarding and other things. So I want to thank you all. Thank you, William. That was great, awesome, really helpful. Thank you all who joined us today. And we will probably be doing more of these soon. Let us know what you want to learn about, what you want to hear more about, and we will try to produce that content for you while we can, when we can. Thanks so much. Bye.
Thank you.